Well, welcome again. The court is ready to hear the case of State versus Kansas, appellee for Nicole Willard, appellant 125812. And I'm ready for your appearances, please, counsel.
May it please the court, Dylan Pryor, Assistant Appellate Defender, appearing on behalf of Nicole Willard. And I request 3 minutes for rebuttal.
You may have that.
Thank you.
May it please the court, the appellee appears through Brian Koch, Assistant Reno County District Attorney.
Thank you, counsel. Appellant, you may begin. And you said 3 minutes.
Yes, please.
I've got it.
May it please the court. Sergeant Cole Long and 3 Hutchinson firefighters seized Nicole Willard when they shook her awake, surrounded her, and would not let her leave. The state agrees that this was a public welfare stop, but it asserts that Long running a warrant check did not transform the seizure into an investigative detention. As our Supreme Court has recognized, however, what begins as a welfare stop can become investigative detention if police conduct changes.
So you're claiming she was actually seized in the Fourth Amendment sense by the firefighters?
That's correct.
Do we have any authority to that effect?
So it's rare when we have firefighters. Like, to begin, I think if there were 3 officers instead of 3 firefighters, there'd be no doubt that what happened was a seizure. But it's a little tough because we have the Brittingham and the Smith cases, but those were both searches. But they give us tests to determine whether state actors are conducting the sort of governmental action that the Fourth Amendment and Section 15 of the Kansas Constitution Bill of Rights restrains. And that's if whether they're acting within the scope of their employment and whether it's in coordination with law enforcement. In this case, we have Fire Captain Ian Arndt testifying at the suppression hearing that firefighters, EMS, and law enforcement all respond to these welfare checks and they all respond together. When we look at the facts of this case, you can tell that Long and the firefighters are working together. And in fact, Fire Captain Ian Arndt brings Miss Willard's name to Captain Long. So the firefighters are they're working within the scope of their employment. They are working with law enforcement. They are doing the sort of governmental action that the Fourth Amendment and Section 15 restrain.
Do we know why he gave the law enforcement officer her name?
We have no testimony about that.
Okay.
All we know is that he gave her the name. 30 seconds later, Sergeant Long is running a warrant check on that name.
But around that same time, if I recall, she makes a spontaneous statement that I think I'm going to jail.
Yes.
So how does that play into the analysis?
Well, there's just no testimony from Long that he thought, oh, she must have done something wrong. I mean, it is the state's burden on these motions to suppress to prove by preponderance of the evidence that the officer has reasonable suspicion to, turn this into an investigative detention. And there's no testimony. I guess there's that errant statement. It could be Miss Long. She had just been shooken awake, found 3 men standing over her. It's not immediately apparent that they're firefighters. And then Sergeant Long gets on the scene. These firefighters are continuing, they're just persisting, trying to take her vitals. And she just wants to leave. And so in her mind, she's not being allowed to leave. And probably to her, it's not that she's done anything wrong, but just from what it seems like, they want to take her somewhere. There's an officer on the scene. And I don't even think that she knew she had a warrant, because when Officer Long informs her, you have a warrant out, she goes, no, I paid that off. So she didn't believe that she had a warrant out. So
It's strange to think that nothing changed as far as her circumstances, and yet we're going from what you'd say was a seizure by the firefighters to an investigative detention by the law enforcement officer. I mean, she didn't know anything that he took her name, ran. I mean, nothing changed as far as she was concerned.
Well, actually, I think that's even more pernicious. I mean, think again, so replace the firefighter, say it was Officer Long arriving with his partner. His partner, they get her name, she wants to leave, but her partner's like, Long's partner's like, let me just check your vitals. While the partner's checking the vitals, Long walks away and surreptitiously runs her name for a warrant check. In her mind, she's like, okay, like I can't leave, but they're just checking my vitals. She doesn't know that they're investigating her. So I say that's perhaps even worse than the typical case that we see where an officer takes an ID and holds them there, decides to run a warrant check. Because in the person's mind, Miss Willard didn't want the help, but they wouldn't let her leave, so she had to eventually take the help. She had no idea that she was being investigated, but she was seized. And so I think what's most important is to look at the officer conduct, because the prohibitions of the Fourth Amendment, they go against the state. They're what the state cannot do. And specifically, the state cannot conduct unreasonable seizures. And so what public welfare stops are is they're seizures. That's what a panel of this court said in Moran Espinosa, based off what our Supreme Court said in McDonald. What we have here is a seizure, and it's a suspicionless seizure. You don't need the officer doesn't need any knowledge of criminal or civil infraction to conduct the seizure. And the reason we allow these, that it's essentially what looks like a Terry stop without suspicion, is because we put a circle around what an officer may do during that. They can only see somebody if they have subjective, articulable suspicion that the person's in need of assistance or in peril, and they can only render the aid or assistance necessary. And so when they step outside of that, then they're no longer conducting the welfare stop. They're exceeding the justification that allowed them to seize the individual in the first place, because they're no longer strictly performing the community caretaking function. They have begun investigating that person. And the reason that the community caretaking function is allowed sort of as an exception to the warrant requirement is because it is totally divorced from the detection, investigation, or acquisition of evidence relating to a crime. When you're running a warrant check, as a panel of this court said in Manwarren, that is unrelated to any reason for a welfare stop. It is purely for investigative purposes. And so when Long ran this warrant check, it was not to further any underlying justification for seizing Miss Willard. It was purely to investigate her. If my
Talk to us a little about McKenna.
Absolutely.
You're aware of that facts. I think we are as well. Does this fit that type of exception? Because wasn't there some indication that she was either going to need medical help and to be transported in an ambulance, in which case it would be nice to know who you're riding with if you're an emergency responder, or she might be taken to jail, in which case he was going to have to haul her there, the law enforcement officer.
Certainly. So I'll take it in two parts. First, the medical part. What we have on the facts here is a firefighter literally telling Miss Willard, nobody has any intention of taking you anywhere. 2 seconds later, Officer Long is running a warrant check. So it is much different than McKenna, where Officer Stiles says, my practice is to take these people home. He was intending to take her somewhere. Long didn't testify that he was planning on transporting her anywhere. The firefighters literally just told Miss Willard that they weren't going to take her anywhere. And so the state argues that, well, EMS might want to take her somewhere. And so, but that means you can run a warrant check anytime during a public welfare stop, because you say, well, at the beginning, we don't know whether we're going to need to take somebody somewhere, so we should just be allowed to run warrant checks. And I just think that's wrong. That's just backdooring investigative detentions through the pretext of a public welfare stop, which our Supreme Court in Mark said you cannot do. Then as to jail, I'm assuming if he's taking her to jail, there's an arrest. Either there's a felony or a misdemeanor with one of the three exceptions that he can bring her in. At that point, yeah, because he'd have reasonable suspicion, he can absolutely investigate her. He can run that warrant check. But at the moment that he runs the warrant check in this case, he doesn't have a reasonable suspicion. There's no evidence of it. And there's no evidence that he's going to take Miss Willard like the officer in McKenna. He didn't testify to that. Firefighter didn't testify to that. And the state wants to say, well, maybe EMS would have. But in that case, you just run a warrant check every time during a public welfare stop, and you eviscerated the entire underlying purpose for it.
Let me ask you a question. So in the Ellis case, the court really focused on the timing of the events. And so, they said it was lawful until the point the public welfare stop ended, and then it became investigatory. So under our set of facts, what is our timeline? When did it turn into an unreasonable seizure? And explain that.
Okay, I say it turned into an unreasonable seizure once Sergeant Long ran the warrant check. And the reason why is Ellis is like Manwarren, where it's just a lone officer on the scene. So the court is concerned they take and retain the identification, and the person cannot go. Here, however, Long didn't need to do that. Long, because the firefighters had already seized her. The problem with Ellis is that the officer kept the person there beyond the welfare check. Here, however, we have Long running a warrant check during the welfare check, and that just expands the scope. And essentially what the state is asking is that to draw a bright line rule to say, so long as this doesn't extend the period of time, a warrant check is perfectly permissible. It is a reasonable seizure under the Fourth Amendment. That's wrong, because the community caretaking function, which is the underlying basis for public welfare seizures, is that they are totally divorced from the detection, investigation, or acquisition of evidence relating to a crime. Running a warrant check when you're not going to transport somebody like in McKenna or in Moran Espinosa, where officer safety is a true concern, there's just no purpose for it other than investigating the individual. And so it may not exceed it temporally, but it definitely exceeds the scope that allows the officer to conduct the seizure, well, it's considered a reasonable seizure under the Fourth Amendment. If I may ask, how am I doing on time?
You have 2 minutes.
Okay, perfect.
And tell your rebuttal time.
Okay, perfect. But I believe I've kind of touched on everything. I've laid out, because the state, we don't have the transportation exception like in McKenna. It's not like Moran Espinosa, where a single officer finds himself with 3 strangers on a quiet stretch of road, and he knows he's going to have to spend an extended period of time with them. So this court suggested he might be able to run a warrant check. Here we have 4 state actors and Miss Willard. There's just nothing in the facts to suggest neither Fire Captain Arndt or Sergeant Long ever testified that they were in fear for their own safety. And just watching this video, aside from Miss Willard not wanting to be there, this was a relatively genial seizure. She didn't want to be there, but she was argumentative, but she wasn't really fighting back. She just wanted to go, but the firefighters wouldn't let her go until they checked her vitals. And so the only way I believe that this court can affirm the district court's ruling is by drawing a bright line rule, by adopting the state's test that so long as an officer running a warrant check during a welfare stop does not extend the period of the time, that is a reasonable seizure under the Fourth Amendment. But as I've stated, that goes against the entire reason that we allow public welfare stops in the first place. It's because they're not for the purposes of investigation. They are purely to render aid to those that are in need of assistance or are in peril. If we say that one officer can render aid while another can investigate that person, then officers are essentially able to conduct simultaneously investigative detentions and public welfare stops. And those are suspicionless investigative detentions. That just is not reasonable under the Fourth Amendment. And so, just to conclude, our Supreme Court was emphatic in Ellis when it said that police may not use public welfare checks as a basis for conducting background investigations or running warrant checks for citizens who may exhibit need for help, for medical attention or police help. And Long exceeded this long, well-established Kansas law when he ran the warrant check on Miss Willard.
You have no beef with him asking for her name?
No, I think that's absolutely fine. And of course, she could have said no. She didn't give him her name. She gave the firefighters her name. She was being cooperative with them. But yes, he can absolutely get that. But once he takes that name and starts investigating it, when he's not going to take her anywhere, when there's no reasonable belief that officer safety is a concern, that exceeds the scope that public welfare stops allowed, and it becomes an unreasonable seizure under the Fourth Amendment. For that reason, we'd ask this court to reverse the district court's ruling. Thank you.
Thank you, counsel.
May it please the court, what the state's seeking here is that this court affirm the trial court when it denied Ms. Willard's motion to suppress the evidence. I think the standard of review here, the facts aren't really so much in dispute. I think everybody pretty much agrees what happens, and there was a video. So I think this court, the standard of review is pretty much unlimited. We're just looking for the court to rule on the legal issues, not so much on the factual issues. The state obviously disagrees with Ms. Willard. The state's position is that she was never seized until she was actually placed under arrest by Sergeant Long. If you look at the Gonzalez test, I think even now there's no dispute that this started out, at least as a welfare check, to two guys had seen this woman passed out under a bridge, and so they call 911. 911 dispatches EMS, fire, and I think it's HPD, dispatch Sergeant Long to investigate why she's under the bridge and see if she's okay. So even when they got there, one of the men who called it in, Sergeant Long, is like asked if he'd gone and examined her, and he said no, I didn't want to get stabbed. I think that put Sergeant Long at least on some kind of notice that there was a potential safety issue, not so much with Miss Long herself, but just in any of these situations where they're responding. And as Judge Schroeder noted in his ruling, they had no facts when they got there. They had no idea why she was there. It was 7 o'clock in the middle of May. She's unconscious under a bridge. When they approached her, she was initially, I think Captain Arndt indicated that when he got up there, she was still unconscious. He had to shake her awake. I don't think it took a lot of effort to get her awake, but she wasn't awake when they got down there. The firefighters weren't there in a Fourth Amendment investigatory sense. They were there doing what firefighters do, which is, in addition to fighting fires, which is making sure that she was all right. They didn't know if she'd overdosed, if she had a stroke, if she was having a mental health issue, if it was something else. And the only way they could find that out was by making contact with her. And Ms. Willard makes a lot of the fact that there were 3 of them, and that they stood close to her, but it's very difficult to render aid from a distance. I think they were trying to figure out who she was. Captain Arndt indicated that was done primarily for their reports. They needed to fill that out. I think there's a lot of good reasons for that. I think a different panel of this court went into that not long after I filed my response in Espinoza.
So do you think she was seized at that moment by firefighters or
No.
not?
No, the state argues that she definitely was not. And I realize that there are times, as Ms. Willard points out, that government actors could see somebody even if they're not law enforcement per se, but I don't think that's what happened here. They weren't searching her stuff. They weren't physically restraining her from leaving. She indicated that she didn't really want the help, but I think they still had to be sure that she was okay before they could just leave her. If she was having some sort of some kind of mental health episode where she was a danger to herself or others, they had to at least check her out enough to be sure that she was going to be okay before they could leave. She had called someone to come pick her up, but that person, from what I could tell, never arrived. I think she got arrested before that person came, if they ever came at all. But no, she was never seized at that point. As the district court noted, Sergeant Long stayed well away from that. It didn't look like he ever got closer than, I think Judge Schroeder said 20 feet. That was exactly 20 feet, but he didn't get that close to her while they were checking her out. But I think he had a right to be there, Sergeant Long, because again, what was this going to turn into? He didn't know, and those firemen and later the EMS guys, they don't carry guns, they don't have handcuffs, they're not trained to restrain people or deal with violence. They're there to render medical assistance to people. And if she had gotten up and attacked them, they would have been on their own. Sergeant Long was there, at least partially, to make sure that just as they respond to every call together, to make sure that wasn't going to happen.
Well, doesn't that prove his point, though, that if it's okay to run a warrant in about every call like that, we would always be running warrants in every welfare check?
See, that's the thing, because not everyone is the same. There are a nearly infinite number of types of welfare checks. I think this is a lot different than seeing somebody stop by the side of the road where the highway patrol pulls up and says, hey, are you okay? And they're like, yeah, I'm out of gas. I'm waiting for somebody to show up and ask if they need a ride. This is different. She is unconscious under a bridge at 7 o'clock in the middle of May. They have no idea how she got there. I think Judge Schroeder pointed out, was she bit by a snake? Was she overdosing? I mean, they had no way to know. When she made contact with the firefighters, she was at least argumentative with them.
But by the time that this happens, that he calls in for the warrant check, Officer Long had actually assisted her in describing to the person on the phone where she was so this person could come pick her up. I mean, he knew who the person was that was picking her up, was helping her describe where she was. It was all very collegial. So I guess to me, I mean, what seems to be missing in this case as compared to McKenna is this element of danger. Like, did anyone on the scene truly felt like she may be a violent felon and we need to call this in?
I think as with every kind of interaction between law enforcement and citizens, you never know what it's going to turn into. And I'm not saying that there was anything here that would have necessarily heightened the danger element, but then again, what threshold do you need before you feel like you need to protect yourself or others? In this case of Sergeant Long and the EMS guy, or firefighters or EMS. And again, if EMS had gotten there, she wasn't cooperative with the firefighters. She just wasn't. When EMS got there, Captain Arndt indicated that she had been more cooperative with them. They were able to check her vitals and do whatever it was they needed to do as far as the medical end of it goes.
Does it matter, counsel, that the officer never articulated, even in his testimony, that he felt any sort of danger or, that there was any reason for running her for warrants other than maybe that's just what he did?
Well, basically his response was that's just kind of what we do, I think is what he said in that instance. Again, I think it would be difficult even for the state to point at any one thing and say like that made them feel scared. Because again, there were at least 4 grown men there, and with one, what's the word I'm looking for? She was reclining against the bridge. She wasn't upright or aggressive. But again, I guess the state's perspective is that it's better for them to know who they're dealing with than not. And this all took place in a very short period of time. They weren't there for 40 minutes. By the time Sergeant Long got there, I think Captain Arnn testified he'd been there a couple of minutes, maybe. They were still making initial contact. So for that reason alone, I think that the Sergeant Long was justified in finding out who he was dealing with, more than just a name. And again, she didn't have to give her name. She could have refused that. She could have not told him. And I don't think anybody's disputing the fact that he had a right to ask for it. But she wasn't coerced into giving it. The firefighters, from the state's perspective, never seized her. She could have, once they had checked her out, she could have just said, no, thank you, I'm fine. And from what I could tell, they would have left. I don't think there was any indication that fire had been like, no, we're staying here until EMS gets here. Sergeant Long never indicated he wasn't leaving. They were doing what they were supposed to do, which was checking on the welfare of this woman. And again, without any sort of facts, they didn't know if, as I kind of mentioned at the suppression hearing, they didn't know if she was a victim of a crime. Somebody could have beat her and thrown her under the bridge, and is that person then going to circle back around to attack her a second time, which is a good reason for Sergeant Long not to leave if that was the case. But he simply didn't know in the amount of time that he had. In the amount of time that he had, it was impossible for him to tell what the facts were. And again, I think it's unsafe to tell law enforcement that they have to just stand there like we live in a perfect world where nothing ever gets violent, or to abandon people who aren't trained to deal with that sort of thing until they're sure that, well, in this case, they were sure that she was okay, and then EMS left, and that's when Sergeant Long actually took her into custody. At that point, she was certainly seized, and she went to the jail, and they found meth in her bag, a baggie of meth in her stuff. But yeah, even if you look at the Gonzalez test, those 3 prongs, this was all done before they got to step 3 in that, which was, once the officer is sure that the person doesn't need aid anymore, then anything they do beyond that would be a seizure and impermissible. They never got past the second step, which was rendering aid. And again, the state's certainly not requesting any kind of a bright line rule or anything. I'm just saying under the facts of this particular case, what Sergeant Long did was reasonable, and reasonableness still remains the touchstone of the Fourth Amendment jurisprudence. I think the alternative would be to say you have to go in there blind and just hope nothing happens to you. Thank you for showing up, thank you for coming out, but you just have to stand there and just wait for the situation to develop. I think that's asking too much, both from the Fourth Amendment and from the people who respond to these things. If there are no other questions, no? Okay. With that being said, we would just ask this court affirm Judge Schroeder's ruling on the motion to suppress, and that's what we're requesting. Thank you.
Thank you, counsel. You have 3 minutes.
Thank you. May it please the court, I have about 2 points on rebuttal. First is the contention that Ms. Willard was not seized by the firefighters. I kind of already went over the test in Brittingham Smith. But I do want to highlight what the court said, our Supreme Court said in Brittingham, is that relying on an officer's job description is an invitation to search and seizure abuse. Ms. Willard absolutely was not free to leave. And the Supreme Court of the United States has given us this test for what a seizure is. It is use of force or a show of authority to which the person submits. Here, the officer, or rather the firefighters, they surrounded her, they persisted in getting her vitals, and the fact that Ms. Willard did not get up to walk away, that's like Brindlin versus California, where the Supreme Court says that, whether a person submits to authority, it all depends on what they were doing before the seizure. A fleeing man isn't seized until he's tackled, but one who's sitting down may submit to authority by not getting up to walk away. The firefighters would not let her leave. They showed their authority. She submitted to it. She absolutely was seized by the firefighters.
What difference does it make when the seizure occurred? Whether it occurred when the firefighters, came versus when she's arrested? Legally, what significance is there?
Well, I think it's more just going at Judge Schroeder's ruling, because he did not even consider the firefighters. Like he said, Sergeant Long was standing away. He never interacted. So in his mind, there was no seizure under the Fourth Amendment. And so she absolutely was. And so that's why I wanted to bring up, she absolutely was seized. And Sergeant Long came and he took part of it when he was interacting with her and with the firefighters. And the second point I want to talk about is the state brought up the idea of like a threshold, that they're not sure when officers can run this. But that's the problem, is they're not asking for any sort of threshold. When we have a public welfare stop, you have to have objective, specific, articulable facts. When we have reasonable suspicion, like a Terry stop, you have specific and articulable facts. When we frisk somebody, specific and articulable facts that the person's armed and dangerous. Here, they're just saying, if it feels like I should have to run a warrant check, then the officer should be allowed to do it. But that's the exception to the rule, and instead they're wanting to turn it into the rule. Like McKenna said, generally, we don't allow warrant checks during this, but the reason it was allowed is because he was going to have to put McKenna in his car and ride with her. And just based on the facts, the state says, well, they were going to have to spend time with her. Well, that's always going to happen. They have to make some sort of showing. They can't just say, well, I have to be around somebody, so I need to see whether or not they have a warrant. That is not reasonable, because then...
But yes, isn't that the test, is reasonableness under all the circumstances, which can vary from case to case?
Yeah, and so that's why we look at like whether or not, that's why we have the exceptions, say in McKenna or in Moran Espinoza. And I think so in this case, we just don't have that exceptions. And I just worry when this state can just always, it just seems like it's an untethered standard. It's just, I felt like I needed to run a warrant check for whatever reason. And it contradicts the fundamental premise of what a public welfare stop is. It is to render aid and assistance. It is totally divorced from the investigation of evidence relating to a crime. But they just say, we just want to run. I'm sorry. I wish I was more eloquent on this point, but it just is not reasonable. There's a reason that we allow these suspicionless seizures of the most vulnerable people, the people that are in assistance, and they want to backdoor in these investigations of those people. And it's just goes against the entire reason we allow it. So this court has no further questions. That's all for me. Thank you.
Thank you, both counsel, for those arguments. We'll take the case under advisement and get you an opinion when we can.